Hello, my name is Nick Guinn, and I'm an intellectual property attorney here in San Antonio, Texas. Today, I'm excited to talk to you about copyrights, what they are, how you protect them, and how you enforce them. First of all, you might be wondering, what are copyrights? Copyright is an exclusive right to the owner of an original creative work of art to exclude third parties from printing, publishing, performing, and a number of other activities, the creative work. It also gives the owner the ability to authorize others to perform those activities. The term work of art in copyright law may sound intimidating. It may suggest Picasso or Van Gogh or the like. The reality is that under copyright law, there's not a litmus test or a threshold for how beautiful or aesthetically pleasing a work of art is. In fact, for example, if I had a bucket of dirt and I threw it up on this wall to see what sticks, I could claim the resulting work as my work of art under copyright law. This also begs the question, what media is entitled to copyright and protection? Well, copyright law includes textual works like books of fiction and nonfiction, articles, poetry, and other written works. It includes performing works like music, sound recordings, musical lyrics, as well as other things like theatrical works. It also includes visual art such as paintings, jewelry, architecture. Copyright and works of art also include motion pictures like film and cinema, video games, animation, and it also includes photography such as wedding photos, high-end photography, and even selfies. As a copyright owner, as soon as the work is put into a fixed media and not just in your head, it's entitled to copyright protection. But it's important for enforcing your rights that you register your works with the Copyright Office. Copyright registration carries several benefits, such as creating a public record of your ownership. It also gives you the ability to sue in federal court in the event that you have to enforce your copyrights. And coupled with that, if you timely register your copyrights with the Copyright Office, you can recover statutory damages and attorney's fees, which in a moment I'll explain why that's a big deal. When it comes to protecting your copyrights, it's a good idea to give a copyright notice on your copyrightable works as well as register. With respect to the notice, that would be placing a copyright notice, that is the circle C, the name of the owner, and the year of publication on the work. So in the case of this video, I'd place the copyright symbol, Nick Guinn, 2023. This tells people who see the copyrightable work that you own the work or whoever else owns it, and that there's a claim of copyright protection. When it comes to registering the work with the Copyright Office, there's an application and it's deceptively simple. You could fill it out yourself, but I would strongly encourage you to consult with a copyright attorney to assist with the registration process. As I mentioned, the application's deceptively simple. Name of owner, name of author, and other blanks are terms that may seem familiar and you may feel like you can fill out, but they have legal significance that you may not appreciate if you don't think about copyright law on a regular basis. You could fill out the application incorrectly and receive a registration from the Copyright Office because the Copyright Office doesn't necessarily know that you didn't provide the right information. But in the event of future litigation, it could come out that you filled out the application incorrectly, your registration could be invalidated, and then you're stuck with nothing as a result. I'd hate for you to have those consequences. So as I mentioned, work with a copyright attorney, and at a minimum, at least get a consultation so that you learn how you should be filling out your applications and do them correctly. Assuming that you successfully register your copyrights, at some point in the future, you might have to enforce them against an infringer. There's several things that you can do. You might send a cease and desist letter to the infringer. Again, I'd encourage you to work with an intellectual property attorney on sending the letter. One, it gives more credibility because that attorney is going to highlight the legal issues, the relevant law, and why you're entitled to your demands. It's also going to show the recipient that you're willing to spend the money hiring a lawyer who specializes in this area and that this is something important to you. It's not a letter that you threw together in 5 minutes. If the letter is successful and the recipient backs down, wonderful. That's always the goal. Unfortunately, that's not always what happens. Sometimes the recipient disregards the letter for any number of reasons, and you may have to file a lawsuit. If you file a lawsuit, you'll do so in federal court, and you will need a federal registration with the Copyright Office before you can file the lawsuit. If you have a strong benefit in having a timely registration. By timely registration, I mean that you register the work either within 3 months of publishing or the registration occurred before the infringing activity. If you have a timely registration, you can obtain statutory damages and your attorney's fees. If not, you're limited to actual damages. Actual damages are the amount that you suffered because the infringer infringed on your copyrights. Sometimes that number's 0. Statutory damages are a number that the government says you're entitled to at a minimum, regardless of your actual damages. And you can recover your attorney's fees, which may be tens or hundreds of thousands of dollars or more, to bring your claim of copyright infringement. You can imagine the teeth that this has in the eyes of the recipient, the defendant, if they know that they may be on the hook for statutory damages and your attorney's fees. Again, it's a good idea to register your copyrights. Last thing I want to talk to you about today is the steps you should be taking on a regular basis with respect to your copyrights. First, make sure that you have permission to use other people's copyrightable works. Do not go online and copy and paste photography, text, video, or the like, and paste it somewhere else online. I don't want you finding yourself as the defendant in a copyright infringement lawsuit if you can avoid it. Second, make sure that you put agreements concerning copyrights in writing. If you're getting permission from someone else or you're giving permission, put those agreements in writing. If you are hiring someone to create a copyrightable work for you, such as a work made for hire agreement, put it in writing. Or you're buying a copyright from someone else, put it in writing. That's the thing, put it in writing. And third, make sure that you're registering your copyrights. If you're regularly creating creative content, register your copyrights on a regular basis. Have a system in place. And maybe you don't create creative work on a regular basis. Make sure that you protect and register the works that are important to you, that you wouldn't want a competitor or someone else to copy or otherwise knock off. Copyright applications are relatively inexpensive, and it's just a good practice. It'll make your life easier down the line. I've enjoyed speaking to you today about copyrights, and I hope you've enjoyed this video. If so, I hope that you'll like and subscribe so that we can give you more great content in the future. I look forward to knowing you, and until next time, stay well.